Ioannis Lianos, thank you very much for joining us today. I propose we structure our conversation, separating it into three thematic blocks. We will start with an outline of your work as the president of the Hellenic Competition Commission. Over the last 2 years, 2.5 perhaps, you did really a remarkable job in this regard, addressing various sectors and being really innovative in many respects. And then we will revert to the Digital Markets Act, which is probably the one of the hottest, if not the hottest issue in the area now. And I obviously cannot resist the temptation to talk a little bit on the theoretical aspects of competition law and economics, perhaps. So these are the three blocks. They are very interlinked. But let me start with the first one, related to your relatively new role. You moved from, or not moved, you expanded your productivity and from various sectors where you've been particularly active over the last decades, and to the more administrative, very kind of important administrative role. And the Hellenic Competition Commission has introduced over the last 2 years several really important, really innovative projects, enforcement projects, and also theoretical as well. So can you elaborate a little bit on those, maybe selecting the most important, the most topical?
Well, thank you very much, Oles, for the opportunity. Always a pleasure to talk to you, and a great initiative. The last 2 years have been quite challenging. Of course, you know, I'm an academic, and somehow I was put in a situation of management, a senior management role as an authority, a competition authority. So of course there was quite a lot of work to be done. I mean, the authority, although it has some very valuable members of staff, is actually understaffed. I mean, had significant problems in terms of very important backlog of cases. In terms of organization, I would say it was organized in a way which did not provide the possibility of interdisciplinarity, because we had a different directorate for lawyers, a different directorate for economists, and therefore, you know, we had to plan quite quickly an important institutional change of the authority. At the same time, try to address the significant backlog of cases. I mean, we had cases since 1996 when I joined. I mean, the average age of cases was 8 years, so it's quite old cases and quite significant number of those. And thirdly, of course, we had to take on important cases and develop our case generation. And of course, you know, they usually say the first 2 years when you know start heading an authority, you're trying to deal with you know, with what has been left by the previous administration. To a certain extent, it was the case here, but we wanted to go further than that and to develop our agenda also during these 2 years. So the first issue about institutional changes, I mean, we tried to introduce more interdisciplinarity. So we created a number of mixed lawyers and economists and IT people departments at the authority, which are sector specific, because the idea I have for a competition authority is that there's a significant role of monitoring of economic activities through data, through the development, let's say, of economic intelligence facilities, and therefore being proactive rather than reactive. So to a certain extent, you know, that was a major, I think, cultural change at the authority. Secondly, we created specific departments like the IT forensic department, or the research, economic research and empirical mapping, basically, of the market type of department, which have actually as a role to enable the competition authority to gather this economic intelligence. And of course, you know, we wanted to develop a little bit more our international reach, so we created a international relations and public relations department as well. So there was a significant institutional change, and we had to convince the staff to first for the lawyers and economists to work together, to be able to form common teams, to develop common ways of understanding issues, and so as to be able basically to cooperate, so to understand each other in order to cooperate better. And I think we've made quite significant progress there. So that was the first aspect, let's say, the institutional reform aspect. Secondly, we needed to establish new infrastructure. I mean, the infrastructure to develop into this new role of a proactive competition authority. And for that reason, we put in place, I think, a quite innovative platform, the HCC Economic Intelligence and Data Analytics platform, taking a little bit opportunity of the pandemic, which to a certain extent made possible for the government to require probably more information from the firms, as it was important, for instance, in order to supervise, let's say, the price of medical products, the medical supplies that was necessary for COVID, and then after that, in terms of enabling the consumers, protect consumers through some form of app which collects information about prices from the major supermarkets, and have a sort of a price comparison app to enable consumers' choice. In particular, in view of the fact that because of the lockdown, basically consumers could only use the supermarkets and they did not have other possibilities. So we use this information and this legal somehow framework in order to develop our own data analytics platform, which is now a significant element of our work, contributes quite a lot to our work, because we collect information about thousands of products every day, basically, and quantities as well for some products from different supermarket chains, but also in terms of station services, different products. So we have been adding different products in this platform, and that enables us, through the creation of specific dashboards to the members of our staff, to be able basically to monitor and supervise the way the market works, and to possibly identify with a number of red flags situations where we might have some indications of collusive activity, for instance, in which case we move further and we do more investigative measures. So that enables us to a certain extent to increase our effectiveness in the way actually we supervise the market. So that was, I think, an important element. It's infrastructure, but also important investments in IT infrastructure in order to be able to use AI in order to be able to analyze the amount of data that we collect from the down rates, etc., which increase quite considerably the effectiveness of the authority, and the different organization of the staff so as to be more productive with the case management software, with a different way of supervising also staff performance, and that brought very significantly positive effects, because the average age of cases in 2 years went down from 8 years, as it was in September 2019, to 1.5 years now. So basically, we finished more than 120 cases in 2 years. And that enabled us somehow to be able to open more cases, new cases, and to be much more effective in the way we deal with cases. So that was, I think, an important element in the way we try to organize the authority at the beginning of this mandate. Of course, in terms of projects, we invested quite a lot on the R&D of the authority. I mean, I think an authority needs to invest on research and development in order to have cases and to also be able to intervene through different ways, through influence or through some form of normative somehow possibilities of intervention. I mean, we have sector inquiries, we have actually the possibility of doing a market investigation references like in the UK. So this is something we invested quite importantly. We opened sector inquiries and we completed them in the supermarkets sector, in e-commerce, In fintech, I mean, a few days ago, we published actually our sectoral inquiry, the interim report on the sectoral inquiry on fintech. We started two sector inquiries, and we had a public consultation on private healthcare and insurance, including the data aspect. I mean, because obviously the more we move towards predictive medicine, the more we move towards the development basically of big data and the use of big data and AI in private healthcare and insurance. I mean, the more actually these issues will come up for competition authorities. We also did the one sector inquiry on waste management and recycling, which is part of our broader sustainable development agenda, which we can discuss later if you want. And we also initiated two market investigation references. Actually, the first time after 2009 was actually the last time, and we had already, the competition authority had done two market investigation references in the past in the oil sector in 2008 and 9. And we opened actually two market investigations in 2020 and 21. One in the press distribution market, where we are facing quite interesting situation with regards to a vertical common ownership. So we use vertical common ownership theories and obviously traditional vertical foreclosure theories to develop in this very interesting and very particular market. I mean, the market of the press. So it's quite interesting because it also involves constitutional values in terms of pluralism, the concentration, etc. And secondly, another investigation in the construction industry, in particular, using common ownership theories, and in particular here it was horizontal common ownership theories, and working with experts in the field like Jose Azar, for instance, or Martin Smaltz, who helped us actually to develop a little bit more our theories of harm in this context. So I think these were, I would say, some of the activities we started, as well as, of course, a number of cases. The first 2 years, mostly finalizing the cases that have been going on in the with the previous leadership of the authority, which haven't been finalized. Finalizing the old cases that were the backlog, but also initiating some interesting new cases. So we, at the beginning of my mandate, actually a month and a half after I took over, we did one of the biggest down raids ever organized by the competition authority in Greece, which was in the banking sector. And of course, we have initiated a number of other investigations, a number of also investigations in digital economy, which will be publicized, I guess, the next few months as the cases progress and come along.
After this outline of really broad activities of the HCC, I wanted to ask you perhaps a question which is relevant to the next block as well. You are constrained in a sense by several concurrent factors. You have ongoing development or evolution in the field of competition law in terms of goals and priorities. You also have limitations with regards to, or what is your relationship, rather, the relationship of the HCC with the government and sectoral regulators? How do you divide the scope of your expertise, and how complementary and how harmonious the work is? And also there are obviously cooperation within the European competition network and beyond.
Sure. I mean, as you mentioned, we are, in terms of the goals and priorities, of course, the goals of competition law are, as you know, a very interesting debate, an endless debate. And I think it's a good thing it's an endless debate, because the goals should depend on the context, on the problems that we have to face, and And these obviously change, I mean, from period to period. I mean, who would have imagined 2 years ago to have a pandemic of the importance that we face, an economic crisis of the importance we faced because of the constraints in terms of lockdowns and other restrictive measures, the logistical crisis that we're facing, the energy crisis we're now facing in terms of the price hikes. No one could. I mean, and of course, and you see that when you are enforcing competition law, that the demands that come to the competition authority from the elected politicians, not only the government, also the parliament as well, of course, depends on the issues and the challenges that they also face in public policy. So, 2 years ago, of course, we did not have the same inflationary pressures that we have now. So now, obviously, these calls for action for the competition authority whenever you have price hikes are pretty normal. I mean, every day basically we receive parliamentary questions basically about price hikes in different sectors. Now, if the competition authority is competent for that or can do something about it, it's an interesting question. So, as you know, competition law is a sort of a very complex and complex tool. It takes a long time usually for competition law investigations to be finalized. I mean, there are very important protections for the procedural rights of the parties because of the level of fines that can be imposed. So one might wonder if competition law is a relevant tool to use in these circumstances where, you have, for instance, give me an example. A few days ago, the Greek government took as a measure the fact that citizens should wear masks inside and outside, and these masks should be of a particular standard, FFP2 type of masks. Now, what happened is that we saw a price hike immediately happening the last few days with regards to these masks, okay? And then we had a number of parliamentary questions and press stories about the need for the competition authority to act. Now, is it something the competition authority should do about? I mean, what are the possibilities for the competition authority to act in time for this? How relevant competition authority's enforcement action will be in this context. So these are issues that we have to face basically every day. And of course, the goals and the priorities change according to the situations we're facing. And I think this is an important thing. So we have broader guidance about the fact that we are there to protect consumers' interests, but these are not the only interests we're there to protect. And we see that, for instance, in agricultural markets, where we are also very much interested in the asymmetry that exists between, let's say, the large retailers and small suppliers. We see it, for instance, in situations where we have a monopsony in the context of a labor market, so where we are trying to protect, in a particular context now, we're discussing the freelancers in some of the markets that are marked by monopsony. So to a certain extent, we have different challenges this time, which somehow require not to completely revise our, the DNA of competition, because that's obviously, but DNA of competition is really sufficiently flexible to accommodate these challenges. And it's part of the hermeneutical work that competition authorities do to develop basically a little bit more the powers they have in order to be able to act according to the public interest. Now, of course, limitations always exist. I mean, the most important limitation is the number and quality of the staff that you have. So I think if you have a lot of staff that is very well qualified, you can obviously do much more than if you have limited staff in terms of numbers and also quality. So, and I think it's very important to invest in the education of your staff and the possibility to attract new people. And I think this is part of, we released today a recruitment video for the authority in order to explain a little bit the careers of the authority and create more incentive for people to join the authority. I mean, the public service in Greece is not very well paid. We all have a huge, pay cut when we join the public service here, but you have other benefits in terms of, working for the public interest and developing an interesting research agenda in an authority that's very dynamic. So that's a positive thing. So, and of course, we have the limitations of competition law itself. I mean, in terms of the provisions, substantive law provisions that we have, which, these limitations have been recognized as well by the Commission, and that's why also they put in place for the digital markets, the Digital Markets Act. The idea that, the situations of power that we are investigating cannot always, be fully covered by the concept of dominant position, for instance, and then will require, to a certain extent, also the intervention of competition law authority against the particular practices and conduct of firms that do not have a dominant position, but in a very fast-moving and complex market where tipping, market tipping works, where you have important network effects, learning effects, etc., you might actually have some anti-competitive effect through without necessarily the company basically having a dominant position or event market. So this is also a limitation that we are facing, and the Commission, of course, has proposed a particular way to deal with such limitation in the context of digital markets. The DMA doesn't deal with the limitation that they have in more traditional markets. And of course, the initial ambition of the Commission was to develop a competition tool, a new competition tool that could also work in more traditional markets like the oil sector, etc., where we are facing an oligopoly and we have the classic, limitations of the Article 101 in this context because of the wood pulp case law, and therefore, the possibility for the Commission to have something like the market investigation reference tool. This did not work at the end because of the choice of the legal basis of the Commission as well in this context. But in our situation, we don't have this problem because we already have a specific provision which enables us to do market investigation references. Now, the issue there is, of course, the fact that with the Commission taking the Digital Markets Act, we are preempted from using this tool with regards to the digital sector, because obviously as we know, the Digital Markets Act preempts ex-ante regulatory tools. It doesn't preempt ex-post competition tools or ex-nunc competition tools like the German Article 19A, but in our context, of course, it preempts us from using the tool, and therefore, there is a question mark about the fact that we might have, the Digital Markets Act protection vis-a-vis through the EU rules vis-a-vis the major gatekeepers, which will be subject to the Digital Markets Act, but we will not be able to act through this ex-ante tool vis-a-vis smaller platforms, significant though, but smaller than the big gatekeepers platforms that could affect our firms. And this is why also we have been reflecting a lot in our context in order to change the regulatory framework in Greece and to provide us the same possibilities that many countries have with regards to non-structural power, in particular provisions with regards to abuse of economic dependence, and the German model of Article 19A. So that's, I would say, these limitations, legal limitations, something that you need to address by promoting legislative change. And there I come to the third issue that you mentioned, the relations with government, because obviously, for legislative change, you need the government, to take the initiative. The Competition Authority doesn't have this initiative. And in our context, we convinced the government to put in place a law commission in order to use the possibility of a transposition of Directive 1/2019 to develop a more broader modernization of competition law agenda, in particular addressing the issues of the digital economy. Now, we made a number of proposals in this law commission that I had the honor to chair. Some of these proposals were accepted, some of them were not. And coming to the issue that you mentioned before about our relations with sector regulators, one of the proposals we made was the creation of a network of sector regulators and the competition authority in order to link both ex-ante and ex-post competition law enforcement. I mean, the regulators, sector regulators do ex-ante competition policy type of they have an ex-ante competition policy role because they are there to open up the markets and develop basically markets that are competitive. The competition authority has an ex-post role. In our case, we have a very specific a need for developing basically a network in order to be able to cooperate and to exchange information. I mean, it wasn't easy to convince everyone about this, and so it did not pass in the legislation, although we do have hopes that informally this network will be constituted. The second issue that we tried to pass and we haven't succeeded was the allocation of powers between competition authority and the sector-specific regulators. What I see, and I think this is something that you can also see in the Penrose report in the UK with regards to the way actually the UK, which is a very mature competition law enforcement system, thinks about the role of sector-specific regulators and the competition authority, is the development of a default, basically, position for the competition authority, I mean, as being the authority that will be in charge of the competition law enforcement, with very specific circumstances in which the sector-specific regulators will come in, either to do the ex-ante regulatory kind of intervention, or in very, very exceptional circumstances, a sort of ex-post enforcement. And I think, you know, in our case, we have a very specific setting. I mean, it's very unique in the EU member states because the competition authority, the Hellenic Competition Commission, doesn't have jurisdiction in the telecom sector and the post sector. We think that this is source of major problems in the sector, and high prices, prices of our telecoms is pretty high compared to the European standards. It's only the telecom regulator that's actually, you know, in charge of this sector, of ex-post competition enforcement in the sector. So one of the suggestions we did for the government was to expand the authority of the Hellenic Competition Commission to also deal with the telecom sector. I think this is very important nowadays, where we see a convergence of the telecom sector and the computing sector. I mean, and also the media sector. I mean, with the presence of you know, integrated companies that are doing media as well as internet, and you know, unfortunately this wasn't accepted. I mean, I do hope that this reform will at some point occur, because Greece and Mexico are probably the only two countries at the OECD that have this very peculiar allocation of powers. But this brings to the fore the issue of how, you know, you allocate powers between the various institutions that you have. What is the analysis that you need to do? And I think, you know, we need to reflect a bit more on this setting and also see the way actually the important institutional reforms that have been taking place in this context the last few years, in particular, for instance, also in some authorities where they merge the competition authority with sector-specific regulators, or provided consumer protection powers to the competition authority, in order to see, you know, through the different examples, what is the benefits and the pros and the cons, basically, of each institutional design. And I think in terms of the sector-specific regulators, I would say that we want to cooperate, but also it's better, you can better cooperate when you know who does what. So there's no conflict in terms of you know, the limits, the frontiers of your competence. I think if these are clarified, then cooperation will be much more intense and more effective. And in terms of the ECN, I think we have a very good interaction with the other heads of the authorities, but also between our staff. I mean, there are different, as you know, ECN working groups. I mean, there's a lot of work going on in this context. The ECN, the last 2 years, took important initiatives. For instance, one which I also played an important role to spearhead was this statement the ACN did with regards to COVID, and in particular with regards to the possibility of certain forms of cooperation being accepted, in particular also and clarifying the situation about maximum price maintenance and so as to enable basically the two companies to limit the effect of the important demand shock that actually we have been witnessing for certain products. The ECN also took interesting position with regards to the DMA. We actually published a statement with regards to that as well. So it is an instrument that we have in order for competition authorities in Europe to basically participate in the discussion and promote their vision of competition law. We do think that, although I would definitely welcome the Digital Markets Act, we do think that the role of competition law is pretty clear. It is still extremely important, and we need to promote the role of competition authorities also in the context of the DMA institutional framework, in order to ensure the synergy between the ex-ante regulatory framework and the ex-post competition law enforcement, which is a little bit the same thing that we try to do also in Greece by creating this network. As I mentioned before, at least this proposal we did with regards to the interaction with sector-specific regulators.
It's remarkable, Ioannis, that these discussions, there is a repercussion with what's going on in the UK, as you have mentioned. There is this Digital Regulation Cooperation Forum and discussions even in the Parliament about establishing this kind of digital super regulator, which would, and then what competences to assign. Is it just supervision or maybe just coordination or steering? Really, whatever option you select, there are some pros and cons, and it's really probably, what is really needed here is kind of determinants and commitment to pursue the model which you have opted, because if discussing pros and cons appears to be a very long process. But you have mentioned several times the DMA. Obviously, I wanted to ask you a little bit about another initiative which combines the HCC initiative with your academic research, namely the attempt to reconceptualize the idea of ecosystems, and it goes beyond digital ecosystems, because in the concept of DMA we are talking mainly about digital, or only about digital ecosystems, whereas the idea which you in the latest paper you have published with your co-author from
Michael Yacovidis,
Michael Yacovidis, you put forward this kind of very intriguing format, and also you try to transpose it to the legislation. Can you just very briefly mention before we move to the DMA?
Let me say that the order is different in the sense that we have been in the Law Commission trying to think about the way we can reform the Greek competition law for the digital age, but more generally for a complex economy. I don't really like to discuss the economy as being a digital economy. I don't think there's a digital sector and a non-digital sector. I also do not think that it makes sense to say that we apply something in the digital field. I mean, what is digital and what is non-digital is extremely unclear. I mean, Airbnb is both a digital and a non-digital platform. I mean, in the sense that it's digital, of course, but at the same time, it has non-digital elements because we're talking about hotels and rooms to let and services of guides, or the Airbnb experience. So this is to show that the distinction between digital and non-digital is a little bit artificial. But for us, to a certain extent, it was to think about the complex economy, and I've been using in my research the concept of the complex economy. I think I've been one of the first academics in competition law to refer to complexity economics a few years ago in the way that this could be used in competition law doctrine and enforcement. I've been a big fan of Brian Arthur's work and of course of many other teachers of complexity theory, in particular complex economics. So for me, it was to deal with this type of, more complex economic settings. And why they're complex? Because, we do not have this kind of clear, competitor versus non-competitor type of, if I want to simplify things, classification that we have in competition law. I mean, by these types of substitution that we do in order to see if, but when we define a relevant market, to see, what is in the relevant market, what is out of the relevant market, what is a complementary, basically, product. We have situations that are more complex because you can actually be a competitor and at the same time, co-develop and co-produce a specific service or product with that particular entity in a way that is without necessarily having a proper, basically, design, in the sense it's basically done sometimes or even organically because of the creation of this ecosystem, okay, which has obviously their rules and sometimes, it has an orchestrator and but at the same time, it's basically something which is a field of a mixture, an element of complexity in the sense that the relations between the companies part of this ecosystem are both relations of competition and relations of, co-development, basically, and collaboration. So, and I think, this element of complexity, which we saw, we try to tackle in our new law, develop this research program on ecosystems, because we actually started writing because it was the only way for us to clarify first our ideas about it, and secondly, to explain to other members of the commission, to convince them with arguments that the current framework of antitrust wasn't sufficient, and we needed to basically, conceptualize ecosystems and to also, develop provisions which are computational provisions which address the issue of ecosystems. So the research was actually the result of a quest for policy making that led us to do the research in order to be able better to do the policy making. Actually, it's a way. Actually, it's a different thing that me coming with a prefix idea and trying to implement it in policy. So it was completely the opposite. So and therefore the agenda came up also from the fact that, once we started with this, we had to define what is power in the context of an ecosystem, what are the metrics of power in the context of the ecosystems, power being basically a very important element for triggering competition law intervention, because there's no need to intervene in case you don't have some, an entity with power, which can abuse its power, either in collaboration with someone else or imposing its will to someone else. And to other market actors and players and ecosystem actors and players. So this is also the agenda with, we have research agenda with Bruno Karbala-Smichowski about the concept of power in ecosystems and the metrics of power in ecosystems. So this agenda came up actually out of this, policy problem. Now, in my view, I think the current framework in the EU, and as you mentioned before, we need to think about what is the problem we need to address, and then what is the toolkit that we have. I think that there's no possibility for one tool to deal with all the problems. So that's why you need a toolkit. And you need to be very careful, though, that this toolkit is not leading to bureaucracy and to limitations of innovation, and so it needs to be a little bit of a toolkit that is flexible and enables actually the authorities in charge, the adjudicators, to use it according to the problems that they have to deal with. So I'm in favor of developing this toolkit, and at the same time being careful about the synergies of the different tools, and when you use one tool and not use the other one. So, and I think right now we have had a discussion about the problem. So there was a discussion about the problem, this gap in competition law enforcement that needs to be filled in with some other form of intervention, regulation, or other competition law provisions like abuse of economic dependence, or the German the paramount importance thing, or the Greek provision on abuse of ecosystem power. And then, you know, there's the issue of the toolkit that you basically develop, the issue of the institutions that need to enforce this toolkit, and the relation between these various institutions. Because at the end, you know, you want something that works, you know, together, and that doesn't create more problems than actually what it tries to solve. And I think in our discussion, we focus a lot on the first issue, or the problem, a little bit on the toolkit, but not so much so far on the issue of the institutional design. And I'm very happy that we're now moving towards that. The last few months has been an important discussion at the DMA with regards to the role of competition authorities, the presence of other regulators, the GDPR regulators, you know, the data protection authorities, the telecom regulators, whatever. So, and I think this is really now, and you know, when this should happen at the commission level, it should be at DigiComp, it should be something else, DigiConnect, together with DigiComp. So these are institutional issues. I think, in my view, these institutional issues should have probably been dealt a little bit before, because I think that according to the institutional design that you have and the institutions that you have, this affects also the substantive law, I mean, that you're going to apply, and the range of opportunities that you have for intervention. I mean, it's a different system when you have the judiciary involved as primarily enforcing it, and a different one if you have a sector-specific regulator, a different one if you have a competition authority. So I think, you know, maybe, you know, we have been doing a lot of discussion about the problem and the toolkit, and not so much about the institutions. And this discussion, institutions have probably happened much earlier. But anyway, we cannot avoid it now. So we need to have this discussion and see how this evolves. From my point of view, we also need to take into account the diversity of the situations we face in each member state. I mean, it's a different thing in a member state where you have, you know, very strong position for platforms that are also local platforms, and different, you know, situation in a state where you have mostly a complementors economy. Yeah? So, because obviously we're thinking about platforms and complementors. I think obviously that will affect the way actually, you know, this particular member state will see the problems coming out of the presence of important platforms in the economy. But certainly there is, so there is room for national experiments, and I think it's very good for national experiments to happen in this area. So I'm very much in favor of the DMA approach, which is to say that, well, the DMA is not incompatible with, and this is in recitals, I think 9 and 10 of the DMA, with national competition law provisions that even go further than Article 102, for instance. So there is compatibility, which is recognized, and I think this is good because it enables member states to experiment and to have through, and this is a benefit of federalism to a certain extent, these different experiments, and therefore to see how, you know, things work and be inspired at the European level. And it's also possible to have the DMA, of course, because for smaller member states that do not have really the weight vis-a-vis this major platform, some of them basically now having a market value of more than $2 trillion. I mean, Greece is is an economy which has, I think, around 180 billion euros as a GDP. I mean, how, you know, competition of such an economy can deal with a giant, you know, $2 trillion basically. Yeah? So in this context, you know, it absolutely makes sense to have an EU authority that deals with these platforms, and therefore we are very supportive of the Commission's initiative and of the Commission's role, and in particular the role of DigiComp, because we think that the synergies that we need to develop between ex-ante regulation through DMA and ex-post competition enforcement are an extremely important issue. And there's no other institution within the EU Commission than DigiComp to be able to basically have the competence as well as the vision and the mountain top basically vision of the interaction between the ex-ante regulation and competition enforcement.
I see, but let us focus on this issue a little bit more. Because, you know, on one hand, we see the ECN showing remarkable unanimity in its kind of manifesting its voice to allocate more power to the national competition authorities for obvious reasons, and most important to them, or many important reasons you have just mentioned earlier. Also in the Parliament's latest first reading DMA, as well as in the Council version, we see that both institutions try to move it closer to this kind of more engaged role, to allocate more important role for national competition authorities and sector-specific regulators as well, and governments. So while in the same time try to stress that it is for the Commission to pursue this kind of exclusive enforcement role. Nobody discusses designation. I mean, designation, it's clear that it's for the Commission, but in terms of enforcement as such, non-compliance issues, there is kind of the debate. And here we see the remarkable kind of a convergence between the orthodox critics of the DMA and orthodox supporters. Orthodox critics might say that, well, if the tool is indeed 114, so by having national competition authorities involved in this process, we would sooner or later have some elements of fragmentation. And the orthodox supporters say, look, we need exclusivity, even in enforcing such delicate piece of juristic mind as DMA is, with its kind of participatory model where the power of the DMA is not only in enforcing obligations, but also in somehow turning blind eye to some practices, and thus we could have situations similar to what we have with leniency, yeah, where basically by and private enforcement. So this kind of different visions where we try to refine the mechanism. Do you think it would be possible to fine-tune it during this trialogue in a way which would somehow encapsulate the advantages of both worlds, or it's kind of dichotomic and it's a difficult choice, and there must be some compromises, substantive compromises being made?
I mean, I think this is an interesting debate happening right now, and obviously you can't predict the outcome of that debate. I think, as I mentioned before, I see a lot of benefits having a centralized authority, the European level, the European Commission dealing with these gatekeepers. I think that we need to be careful that the DMA actually, although it should have some flexibility, is not too flexible. I mean, in the sense that it's basically an important intensive form of regulation, regulatory intervention. So it needs to be dealing with very specific gatekeepers. So I'm very, very much in favor of the thresholds that we have, and to keep them, and not to somehow dilute and bring in more and more platforms there. I think we need to have in mind that the competition law tool or modified competition law tools might deal better with these platforms, and therefore there's no reason for the DMA to expand with regards to that. Now, in terms of the various types of conduct that are mentioned in the DMA, of course, these need to be further clarified, and of course we need to be more flexible there in terms of, in case through experience we see that there are some type of conducts that create problems. I mean, they probably could be added, and I think the DMA offers some form of future proofing to that. There are different ways for DMA to have this future proofing with. And I think the competition authority should play a role, because in order to maintain the synergy with competition law. But I think the DMA, because of the fact that it's about these giant gatekeepers, very specific gatekeepers, I think there is a reason for that to be at the level of the European Commission exclusively, and the member state competition authority to play an auxiliary role in case there's need for information gathering or in particular the interaction with the competition law tool. So that's a little bit my vision. Now, there is, of course, a private enforcement aspect which you raised, which is a very important difficult issue. I mean, how this will work. I mean, of course, the regulation has direct effect. I mean, people can go to the courts. And I think this aspect of how, this private enforcement of the DMA could work with the public enforcement of the DMA is not very well still, explained and clarified. Of course, as we know, private enforcement, also the competition law field, we have been talking a lot, but there's not really much that has happened. I mean, we haven't changed, at least to my understanding so far, the relative importance of public enforcement vis-a-vis private enforcement in Europe. I mean, more or less, public enforcement is still the most significant type of enforcement in Europe rather than the private enforcement. So we need to see, how this could work also at the DMA level. So I guess, for the time being, it's more about, moving in, implementing it, and trying to assess it in a year or in 2 years' time, and make the adjustments that are necessary for this tool to work, as well as with the rest of the competition law provisions that are now adopted by member states. Because as I said before, there's always this possibility for member states to come in for the companies that are platforms that are not gatekeepers like the DMA, but have significant power and can actually have significant effects to the economy. Now in Greece, unfortunately, and I guess because probably we're the first ones to put it in place, this concept of ecosystem, the government actually at the end seems not to put forward now at the legislation, although it has actually publicized this and we did a public consultation, will not move at this time with these particular provisions. They want to wait and see what happens at the European level first, of course, having this in mind for the next level. I know that there may be many other, not only member states of the EU, but also other countries that are thinking about developing provisions concerning ecosystems and have been inspired by our proposal and the way our law was drafted for their own legislation. So we probably see some developments there in the near future. I think what we try to present with this research work, is to somehow make the competition lawyers and economists as well to realize this important aspect of engaging with complexity and in our way of thinking and complex business practices, and in particular, develop new concepts that could have more explanatory power than the concepts we already have, and could also be more elegant and easily used in enforcement than the concepts we have now, which somehow, push us sometimes to make very artificial type of market definitions, and and we explained that in the paper. More difficult, let's say, intellectual creations intellectual frameworks, to address problems than the ones we could do with the concept of ecosystem. So, and I think this is, adding more, being able to address complexity more easily. I mean, this is, I think, one of the main benefits of the concept of ecosystem.
All right, let us now move, Ioannis, to the last block. And one of the distinctive features of the DMA, perhaps, is its kind of asymmetric scope. And in several incarnations, it is asymmetric in terms of designating or selecting specific addressees of the rules, but also in terms of designing the obligations, particularly within the obligations of Article 6.1, which are essentially supposed to be intentionally vague, and thus open to interpretation, and thus moving closer to this bespokeness as we have envisaged in the UK. So we have a kind of more creative role of the enforcers envisaged in the system itself, and in order to be more proactive, more creative, in the UK, again, we're talking about pro-competition regime for digital markets. So this kind of proactive modality is being used more often, not only kind of restoring the status quo, but trying to shape the digital, not digital, any market, but digital in particular, at least in the rhetorics. This kind of leads us to the situation which is relevant to the theoretical aspects. Yes, so we know that we are now confronting two tectonic kind of visions about competition policy. The one which implies the existence of the situation which is kind of where competition is flourishing in its absolute form. It would be a condition of perfect competition in some kind of illusionary, perhaps even perverse sense, and where any market imperfection or market failure has to be remedied and restored and addressed, and we will thus return it closer back to the situation of kind of happy, flourishing markets. And another one, much less axiomatic, and again I refer to this term axiomatic, which you have brought to this to the scholarship, Antitrust scholarship, back in 2009, if not earlier, in your really astonishing paper, Judging Economists, where you're talking about perception of economic. And remember, we're talking about 2009, when these ideas were really iconoclastic. Now they are much more mainstream. So basically, the vision is that we have kind of perception of the objective truth, which has to be kind of achieved versus the vision, kind of polycentric in several senses of the term, where there is no such condition, and it's kind of competition of different interpretations or perceptions of reality, which are partly correct, partially not. So can you reflect a little bit on this from the perspective of 2022, essentially, and from after enriching your vision with this enforcement, incarnation or dimension?
Well, thank you very much. I mean, broad questions. I'll try to respond as best as I can. So, I mean, with the first issue you mentioned about the proactive role of competition authorities, I think, look, competition authorities are, of course, there in order to, the more traditional way of dealing with bringing cases and dealing with problems that have been identified through various investigative measures like down raids, like complaints, whatever. So we have a reactive role to a certain extent, and it's a painstaking process of gathering evidence, assessing that evidence, and obviously testing that evidence first at the board of the authority, the hearings, etc., procedural rights of the parties, and then eventually at the courts. So this is a little bit the DNA of the competition law as we have so far. Now, I think now what we're seeing happening is because of the very important changes that are taking place. First, technological changes. These technological changes lead to changes to economic and business models. And these economic business models, of course, they change first in the area where the technology applies, like the digital economy, but then because they are bringing in immense profits and not only in the traditional sense, like you are making and put higher markup, but in the sense of your assets are basically valued by financial markets, because this is also part of the financialization element that we haven't really identified very much in computational analysis. We try to bring important work, I think, we're doing with Andrew McLean, that at UCL, about financialization, I think. So we have these other strategies of monetizing that actually are developing, because of, not the classic traditional ones. So all these obviously, put competition authorities to the task of reflecting about maybe having a more proactive role in creating markets that are competitive. So reflecting more on the market setting framework role of integrating more competition in the way markets are designed. And this is very important nowadays because, of course, of the importance of the the transition to also the green economy, and secondly, the challenge that we face because of these low probability, high impact events like pandemic, and maybe in the future climate change. So to a certain extent, we have basically to transform the economy, transform the way we think about production very quickly. And of course, in that context, competition authority cannot just stay there and wait and bring cases, but they need to be part of the table. Not only the legislative table, where competition principles should be promoted and preserved, but also at the table where the business strategies, the new platforms are created, and these new platforms with the infrastructure of the new economy that will emerge after this crisis, right? Which is not a crisis in the sense that it's a change. I mean, it's a transformation moment that we're living right now. So that's why you need to develop a theory about the proactive role for competition authorities and new tools, new ways for the competition authority to interact with the stakeholders. And this has been an important reflection for us in the context of this project we initiated in September, the summer 2020, on sustainable development. The more we move towards sustainable development goals being part of the goals of the state, I mean, because we are all countries now are preparing themselves for the transition to a green economy or to ways to mitigate the climate change, okay? Then you need to think of the role of competition authorities in this transformational moment, and that's could not be the same as the one we had when business was going as usual. Okay, so and we need to think about new tools that will make us relevant, and will actually enable us to prevent problems. So that's why we have been thinking a lot about. Apart from the fact that we need to integrate sustainable development in our ways of thinking and competition cases, etc., and how to do it. I mean, this is an interesting project. We have been cooperating a lot with the Dutch competition authority in this context. But also, we're thinking about new tools to deal with that type of transformational issues or these high-impact, low probability events like the pandemic. And this is why we want to use more the tool of sandbox, for instance, which is a new tool that, in the conceptualization of this new tool in competition, I mean, it's an old tool in financial regulation, but the conceptualization of that tool is that it is a tool that enables you to better deal with the complexity of transformation and the knowledge asymmetry that exists between the competition authority and those that are driving this transformation of technology, economy, business models, etc. It enables you to be flexible, but at the same time, not at the price of anti-competitive behavior, because you are monitoring the specific activities. That's what is a sandbox. I mean, it's a space of experimentation, but supervised experimentation. So it's not like a carte blanche, it's a supervised experimentation. And that is actually, I think, an example of these new ways of these new tools, basically, that we need to think, and these new types of engagements of a competition authority in this new context that we're facing of important change, technological and economic. Now, this obviously, apart from the tools, we need to start thinking also about the way we think about competition. I mean, what we're trying to preserve and protect. What we have been discussing many years now is this move towards real competition. I mean, yes, I mean, it's very helpful to have this important economic tradition of neoclassical price theory, industrial reorganization, in order to help us making better decisions. And I think we have made probably better decisions because of these tools. But these tools have been framed in a long process since the end of the 19th century up to basically now. Okay, and they have been there to deal with sometimes different economic contexts of what we're facing now. and different social demands. I mean, in a different way also of somehow dividing the various fields of law. I mean, we had, very, like a little bit like Fordism in economy, we had a sort of a Fordism in the way the legal system. So I mean, labor law does this, competition law does that, Now what we're facing, and I think this is something that I'm researching on right now, is a situation where it's more problem solving base, and then we need to develop, let's say, some legal thinking and legal frameworks that will be context specific and would sometimes blur the distinctions we have right now between the various fields of law. Okay, and I think this is an important challenge for lawyers and the legal system, and how to learn. I mean, from a period where we had very clear tools that were doing, competition law cannot do this because this is not. Now we might have to think a little bit more creatively and in synergy with other fields to see, how we can solve this problem. And this type of thinking of collaboration, collaborative thinking, and developing came out to me also through my interaction with labor lawyers in the work we have been doing together with Nicola Kounderis and Valerio De Stefano with regards to the freelancers and the way actually the gig workers. I mean, I don't like this term, but I mean are dealt in the economy, and how labor lawyers are seeing the problem and the tools that they have to deal with the problem. How competition lawyers will do the same, and how we need to develop some synergy. The same issue, I will say, will come out and has come out in our joint work with Nig Economy. This is concerning privacy and trying to see privacy from an economic perspective and as an externality problem in order to deal with that problem, okay? As a market failure, problem, rather than externality problem. Also an externality, but mostly market failure, which is kind of more broader. The same thing actually will occur, I guess, with sustainability, not only environmental, but also social sustainability. Because right now we're thinking about environmental sustainability, but sustainability is broader than that. The 17 objectives are also, social sustainability objectives. That's, what motivated my work about polycentric competition law and the need to develop new tools to use in the polycentric competition law context. For instance, like agent-based modeling, which I've been referring to back in 2008 in the polycentric competition law paper, and then develop a subsequent work also with Andrew McLean and also other colleagues.
2008?
18. Yeah. So, and of course, that means, and I come back to the issue that you mentioned before, that when you have to deal with broader perspectives, you need to deal with different sources of knowledge and expertise, which you need to integrate those into your way of thinking. Okay, and that's why it's interesting to think the same type of tensions that we had when we, at least in Europe in the 1990s, were dealing with the economics. I mean, and the economy is now becoming part of the group of competition law professors or professionals, let's put it that way, because at the time we were creating the merger control in Europe, when this is when the first economic consultancies were developed in Europe in the early 1990s, and therefore we had to develop new ways of integrating this new knowledge and judging about these new economists. I mean, these new stakeholders and what they were saying. The same thing I think will have to happen with these other sources of knowledge that come in now in our professional project, which is now a common professional project with economists, I would say, competition economists, and new people like data scientists, for instance, and or artificial intelligence experts, where we are using data in order to make better predictions about possible behavior and develop in more computational competition law and economics type of approaches, and therefore we need to deal with these with these new sources of knowledge and expertise. So from my perspective, therefore, and this is also part of the work we have been doing at the Greek Competition Authority, we had a project on computational economics. We actually published a inception report. Actually, I think the first one was published in December 2020. I mean, it was done in December 2020. It was published in January 2021. It's a little bit about that. I mean, issues like, you know, how you deal with evidence that comes out of an AI type of process in courts about predictive modeling or simulation technique or an agent-based modeling. I mean, this is the type of issues that we need to tackle in the next 2 years. And I think it's a very important, and I'm very happy that there are a number of projects in the computational economics. I think we need more projects in this context. And also in agent-based modeling, and to see, you know, how this works. Agent-based modeling, I think it perfectly fits the polycentric model of computational law. And this is also why, you know, in the article about polycentric computational law, it's referred specifically, you know, as a tool to use in that context. And of course, you know, it's very important to invest for competition authorities in these new approaches, and of course also to develop a better understanding of these new sources of knowledge, and see what are the tests, you know, that they will need to develop in order to assess what is, you know, science and what is, you know, non-science, okay, non-scientific, non-valuable in terms of plausibility. And I think that's going to be an important project for also academics in the future.
I cannot agree more. Thank you very much, Ioannis. I think we have managed to ask you quite a long list of questions. I'm sure there are much more to be, you know, to be addressed after your kind of exposition of your thoughts on various practical, theoretical aspects of the development of competition law, economics, and policy. But I'm sure there will be many other possibilities for the viewers to engage with your scholarship and your policy related work as well. Thank you very much for sharing with us.
Thank you very much, Oles, for the opportunity. Always a pleasure to talk to you, and looking forward to reading also your very valuable research in these areas and your theoretical perspective on the topics, which helps us a lot also, competition authorities, to better understand our role and somehow, you know, understand a little bit the way we need to act in these challenging times.
Thank you.
Thank you.